Thank you. Thanks for having us. It's always fun doing these sessions, and I'm really excited to be able to do this with Odette. This is our first joint one. We've definitely crossed paths out in Kamloops, and so with that, I definitely want to say thank you to Baljinder for inviting us. Both Odette and I are located in Kamloops. And so we'll acknowledge that we are on the traditional and unceded territory of the Tecumseh Nation. And I think a lot of that guides, our involvement in the community for sure. So yeah, welcome to our neck of the woods out in Kamloops. Beautiful shot there. Thanks, Odette. So we've kind of split it out into two sections. I'm going to kind of start out with the right side of it. So where do we start as far as our rights are concerned for tenants and housing? And then Odette's going to be speaking to the legal remedies available. And then we'll touch a little bit on at the end on some of the resources that we know of in the Kamloops area for housing and disaster relief. And hopefully, we really definitely want to take a lot of questions and kind of fill what time can happen. I think this summer in particular really showed where there's some gaps in the housing. I mean, as many of you, and I'm sure, both Odette and I are very well aware that even before natural disasters, housing is such a precarious thing for a lot of people in our communities, and especially those that are in a situation where they're renting, whether that be in a manufactured home park or whether it's a apartment or basement suite, whatever. We deal with a lot of vulnerable people, and so this is really important. And the recent rash of disasters around the province it's really exemplified how much we need to pay attention to this. So from our little ability to help out people kind of after the fact is one little thing that we can do, and so hopefully we can pass our knowledge on to you all. So ask questions, and hopefully we'll have an answer. But if not, Odette or I will look it up and get back to anybody on something. So the first thing that we're going to talk about, I'm going to split it out into Residential Tenancy Act and the Manufactured Home Park Act. And you'll see that there is a bit of a crossover with respect to the rights that kind of arise under both of these pieces of legislation. And they are somewhat mirroring. So there will be a little bit of overlap, but I won't focus too much on necessarily on the exact same things, but how they affect tenants differently, because there's a huge difference between Residential Tenancy Act tenants and Manufactured Home Park Tenancy Act client or tenants. So first thing, when a natural disaster hits and it causes a situation in which a tenant has to leave their home, the biggest thing that this creates is a frustration of the tenancy agreement. And so what does that really mean? Our normal understanding of ending a tenancy is that somebody wants to leave, someone's been evicted. There's a reason for, an external reason between the two people, the landlord and the tenant, and that's why the tenancy is ending, and that's usually what we deal with. But in the cases of natural disasters, it's my belief, in my opinion, there's going to be like two things that might affect this. But a frustration means that there's no way of continuing on with the agreement, so the home has been rendered uninhabitable. And so that's really where natural disasters play out. So for example, in Merritt, when we have flooding, the home can no longer be inhabited, or there's going to need to be quite a bit of remediation to deal with that. There's just no possible way for the tenancy to continue. And so it's been frustrated. It's not anybody's fault. It's happened, and for whatever reason, it just can't continue. And so in that case, in a natural disaster, the tenancy then is considered frustrated and can no longer continue. And then both parties are essentially done, right? Now, when we look at this, it differs from the normal things that we see. It's not so much that, a landlord might try to argue that, say, the landlords abandoned the tenancy, like they've just left. They had no choice. There was a forest fire coming or whatever. That's not going to fly. And I would hope that the residential tenancy branch would, if the landlord comes out for an application saying the tenancy was ended early because they abandoned it and is trying to seek compensation from the tenant, I would hope that the residential tenancy branch would acknowledge that, no, that's not actually what's happened here. And it's not a situation where the tenant has decided to end a fixed term lease early. So we kind of have to look at what has led to the end of the tenancy. And in the cases of a natural disaster, if it's a situation where somebody just can't go back, then they just can't go back, right? And so what can happen is that a landlord can apply for an order of possession, just so then it kind of officially ends. But I think in most cases, I think a tenant and a landlord would come to a mutual agreement to end tenancy. And I think that's where my hope would be, that's where a lot of landlords just go rather than having to apply for an order. Because, I can't imagine, if the home is full of mud and water, is not really going to be something that a tenant wants to stay in. So that would be my thought there. So when it's frustrated, it's a usual course of termination of tenancy to end, and the return of the damage deposit is a key right for tenants. But I think we have seen some people get asked, okay, well, we're going to have to keep the damage deposit. Well, that's not quite accurate, right? Technically, if a move-in inspection was done at the end of a tenancy, a move-out inspection should be arranged, and the landlord and the tenant try to come to an agreement to conduct a move-out inspection. But that's really not possible in the situation where a natural disaster is what has ended the tenancy. And so you can't really do a move-out inspection. And in some cases, there's no more home to inspect. So return of the damage deposit really should be occurring, in the usual course of business, because that damage is not the fault of the tenant. There's nothing left to inspect. Damage deposits aren't a component of insurance for a natural disaster, right? It's for if the tenant has done something to, left the tenancy, left the home in a state requiring some repair or cleaning that's beyond normal wear and tear. So realistically, once we know that the tenancy has officially been frustrated, a mutual agreement to end the tenancy has occurred. The tenant needs to provide in writing the forwarding address to the landlord, and then within 15 days, the landlord has to send the damage deposit back or make an application to the residential tenancy branch to retain the deposit. Now, again, I would like to think that in these cases, that the RTB, if such an application was made and a hearing was set for it, that the RTB would quite quickly dispense with that and say, no, you got to pay it. But if a landlord doesn't either provide the damage deposit back or make the application within 15 days, the tenant is actually entitled to double the deposit. And so it's really important to keep that in mind. If you have a person coming to you saying, like, they said that they can't give it back because they need the money to rebuild or remediate or whatever the case, that's not quite what the deposit's for. That's for actions of the tenant, right? And so we just have to make sure that our clients are aware of that, but that also the remedy isn't just simply getting the damage deposit back. The remedy is actually getting twice the deposit if the landlord doesn't meet those requirements. And so often what we'll do is we'll send out a demand letter saying, pay it back or we're going to seek this, right? And so sometimes that will very quickly get that resolved. Now, if the property can be repaired, so if you can stay there, but there's going to be some repairs to be made, you have to make sure that the client has to go through the usual processes. So if it's not an emergency repair, they have to send the landlord the list of things that need to be taken care of, and the landlord has to be given a certain amount of time to make those repairs, right? So if the repairs are something that that the house or whatever can be, the person can still live there while those repairs are being made, then it's just a matter of giving the landlord time to repair it. And so as with any tenancy, the house has to be maintained in a suitable standard, meeting all the health and sanitary standards that are required under the law. And so it has to be suitable for occupation, and that still remains an obligation on the landlord, despite the fact that it was a natural disaster. Now, I suspect that in a lot of communities, there's going to be an issue about an issue with respect to the insurance payouts. I'm just seeing Andrew's question here. Yeah. And that is, that's also the case. And to be honest, if it depends, Andrea, about, as I'm kind of getting to, it depends on how extensive the repairs need to be, right? If the house is entirely like uninhabitable, there's going to be a situation potentially where if the repairs remediation are so extensive and they want to end the tenancy, I think that the landlord, in my opinion, it's going to be a situation where those the new rules that came out over the summer with respect to rent evictions, where the landlord should be making an application to terminate. That's my opinion. I never know what the RTB is going to come out with as far as responding to that type of a question. But I think that what you can do is the tenant in that scenario where, if it's a matter of just a couple of weeks to reconnect the electrical, get the water back up and running proper, if it's something that's only a few weeks and it's not substantially taking over the home, like the renovations aren't to making it so uninhabitable. I think that the standard rent eviction type approach is what's going to be needed in some of those cases where the landlord either has to make an application or the tenant is going to make an application to force the landlord to follow the rules, which is under the amendments to the Residential Tenancy Act, that they have to actually make an application to end the tenancy early, or to end the tenancy at all, to do these repairs. So that's my take on it, is that there ought to be that application. So if the house could become inhabitable again, it's either going to be treated as an eviction to repair or renovate versus just an end tenancy because it's uninhabitable. I hope that answers that concern. Now, if the repairs are emergency repairs and you've asked the landlord, and it's the kind of thing where it's an emergency, that if you can repair it so you can stay, like there's a leak in the roof, something like that, you would have to still follow the same rules under Section 33 to do those repairs, right? So we have to look at like the level of damage or repair that needs to be addressed versus whether the person really has to move out. Obviously, if the basement's full of water and there's serious safety concerns, that's going to be an issue. And so that kind of leads me to the question of, what if the government prohibits access, right? So, that was a huge thing, I think, in Merritt, where a lot of people just weren't allowed to go back for a very long time. And I think there's still actually some people who haven't been able to return in certain areas of BC as a result for a long time now. And so in that case, that basically that frustrates everything a little bit further, because maybe there's something that could be done, but if the government's prohibiting it, that's outside the control of both parties. And so we kind of at that point are looking at, it's more of a termination for cause, right? So again, it's outside the scope of what can be done between the landlord and the tenant. And so the type of notice in that case, it's a 1 month. A landlord notice for a cause, so a 1 month notice, which is kind of frustrating. Yeah. So if we then move on to Manufactured Home Park Tenancy Act, that's I've been doing a little bit of research on this in particular. It's very frustrating. Don, yes. What is reasonable? Well, it depends, right? If you say that there's a reasonable time for the landlord to respond. Oh, do you want to answer this one, Odette? Or do you want me to answer it?
Sorry, I was just doing that so it wouldn't look like we were answering it. I apologize.
Oh, that's okay. Yeah, so it really does depend, I think, on the repair that's needed. If you call them or call the number that's been provided by the landlord for the repair, say for a plumbing incident, and you only wait 20 minutes and you call your own plumber, that's not going to be reasonable, right? So it really will depend on the scenario. Reasonable is one of those lovely words in law where Odette and I joke all the time and go, well, it depends, right? Because it really does. So if it's a matter of like, is it something that can, if it's, say it's 8:00 at night, something's happened, and you get a hold of the landlord, it's like, well, if it's livable for, till the morning, I'll start calling around to get somebody in the morning, and you choose not to, and you make an emergency call for repair that night, that likely won't be considered a reasonable amount of time for the landlord to respond, right? So it's really going to depend. Now, that being said, if there's an emergency repair and it's like, this can't wait because the whole place is going to get flooded if we don't deal with this burst pipe or something, I think in that case, it might be reasonable for you to call somebody if you've waited an hour and they've not gotten back to you. And so it's just going to depend on the circumstances. Yeah, in that case. So manufactured home parks are very precarious, and they have a set of problems that are unique to those homeowners, which is why I find it personally a little bit frustrating, where sometimes with the law under the Manufactured Home Park and Tenancy Act is very similar to the Residential Tenancy Act, despite the fact that there are a much more unique set of issues that face tenants there. So much like the RTA, we can see frustration of a tenancy agreement, and that does make sense. It's if the agreement's been frustrated and it can't continue because the manufactured home park, the disaster has caused severe damage to their essential services that they provide, water, gas, whichever, electricity, and it just can't continue, and it's going to take a lot to repair. Or it's going to be too costly to repair, who knows, right? That creates a huge problem for the owner of the manufactured home who rents the pad, right? Because when we talk about the application of law, it's for people who own their manufactured home but then rent the pad space in a park. And so, now all of a sudden you've got a manufactured home that either you can't access or can't stay there. And that creates a lot of issues for the owner. Again, manufactured home park allows for a landlord to apply for an order of possession as a result of frustration. And so really, you're not being given the opportunity to really deal with the home sometimes in certain cases. And that is a huge problem. Moving manufactured homes is not an easy endeavor. And especially in the situation where there's a natural disaster that people are still having to deal with. It's a very precarious set of problems that arise and create quite a bit of vulnerability in manufactured home park ownership, like in that tenancy scenario. So if the situation has arisen, and I mean, this is actually almost general, this is a very general rule where if you're moving the manufactured home itself in or out of the park, you may have to put up a form of security, so like a deposit, or ensure that you've got insurance that will cover moving the home from the park. Now, I don't know many tenants that would have the ability to afford that insurance or to put up a deposit. And so that creates a bit of a problem. And then if you think about whether or not that tenant can even afford the move itself, right? So if you have clients that are in manufactured home parks, they have bigger problems than just, I need to find a new place. I need to find a new place and the funds to move the home, or I'm in a position now where I have to sell the home. It's a really frustrating thing because the ownership of the home is what's creating the problem. But a lot of people, it's a much more affordable alternative and they're building equity. Most of the time, sometimes depends, by owning the manufactured home itself. And so it's really hard to work out, what the best option is for some of our clients in this scenario, right? Basically, your options are sell the home or renovate the home or move the home. And all three of those are going to be really costly. Whereas a tenant who's renting, say, a basement suite, they're not the ones that are paying for the repairs to make the home inhabitable again. And they don't have to move the basement suite with them or face the cost of getting rid of it. So it's a very frustrating scenario for, I think, people that reside in manufactured home parks, particularly in the face of natural disasters. The cost of it is so much more on the actual tenant themselves. So in that regard, does the tenant have any insurance? Hopefully they have some insurance in place. But my experience is that insurance seems to be a bit of an afterthought as far as, portioning out your monthly budget for a lot of our clients. So then if there's any repairs that need to get done, that's going to be the trick. And it's similar in that the repairs or services, that's where we're looking at is the landlord's responsible for the manufactured home park. It needs to be in that good state of a reasonable state of repair. So if they want to return to the park, they may have to wait out the repairs to the park services so that they're able to have running water and all those services that we need to have a proper level of cleanliness and sanitary standards, right? But if the park is in such a state that you can't return to it, again, it's 1 month notice. You don't get compensation for that notice to end the tenancy because it's just become untenable to have residents there. So then again, we go back to that same problem of, well, what do we do with the manufactured home, right? And so it's a very, very tricky. And so your rights, while they look the same as a normal tenant, there's such a higher element of cost and concern that isn't, in my opinion, properly addressed in the Manufactured Home Park Tenancy Act. So Odette, if you'll flip on, is that it for me?
Well, I actually want to ask you a question, Kelly. You might because I was just thinking about it. And because you're covering this area, but in the Manufactured Home Act, the park can require you to make repairs to your home. Yep. So what do you think would happen in the situation if a flood came through? Do you think they'd have to give reasonable amount of time? What do you think would happen if they immediately were if you don't have your home repaired to this date, or I don't know, there's garbage on your lawn, things that they take. Do you think they could then have you get an order of possession?
I think they could. I think they could apply. They could definitely apply for one. It's hard to say. I think you and I both especially know just how hard it is to say what the decision out of the RTV would be on that. I think in the case of natural disasters, I think that there's going to be a certain amount of leniency, but it comes back to that reasonable question, right? What's reasonable amount of time to get that repair done? And so many of our clients that are in manufactured home parks, they have such limited incomes. And so to do those repairs, I don't know. And this is one thing that I'm a little bit uncertain about, but I don't know if there is a fund out there. I know they announced today for Lytton that there's going to be repair funds for those that are underinsured or have no insurance. But I don't know if the same type of funding is going to be available in other communities like like Merritt, that has suffered quite a bit of flooding. So I don't personally, if I was an RTB arbitrator, I'd look at the amount of time, and I'd also take into consideration undue hardship. I don't know if I'd personally be allowed to do that, but I would definitely, as an arbitrator, want to consider, well, what's this person's income? And is there any way that the park can help with that? It's such a burden on manufactured homeowners. It's such a burden. And unfortunately, there's nothing in the legislation that speaks to undue hardship in that regard. So.
And I wonder too, if there was a decision that came down that seemed very unfair, if organizations like yours and mine
yes.
do the judicial review, and then there would be, so judicial review being when you step it up into the Supreme Court,
yeah.
And saying that the arbitrator's decision was unreasonable.
Yeah.
That might be what we need in this situation in order to have a more proper answer. And I suspect as we're going to see the increase of disasters happening in the province, that there will be the right case to bring forward that way that may change the law and make it a little more solidified, because the RTB is not required to follow each other's decisions. They are, however, required to follow the BC.
The question is, do they? No, I 100% agree. And so in this research project, this is actually one of those things in particular that we're focusing on is the disproportionate application of essentially mirror legislation, but it's such a disproportionate impact on people. So, like if you think about a manufactured home park, much like the rent eviction option, the application of that to a manufactured home park, I think, is a little bit different, and particularly if they're going to say, oh, it's too much to repair and bring it up, so we're just going to issue you all 1 month notices, and because you can't come back, or we say that that it's not there, and then you're going to have some people who don't know their rights and will just scramble to either sell or move the home and incur that cost or loss in some cases. So it's really frustrating that it's such a disproportionate treatment.
That's why I think the research is really important, so you can lobby the government to make it. Because honestly, what really needs to come down is there to be I think the Manufactured Home Act is probably the one that needs the most change.
I do not disagree. There's many things that need changed in the housing department, but yeah, that's definitely up there. So since we're talking about legal sides, I'll pass it over to you now.
So I know many of you will kind of already know this, legal remedies. We know that it has to be gone into the residential tenancy branch, but I just want to start out with some reminders. And if for yourselves or for any clients that you may be dealing with, just to remember that landlords and tenants should try to keep in contact with each other. So one of the problems is a lot of times that if there's a natural disaster and the tenant's being evacuated or leaving, then the landlord's also being evacuated and leaving. And so we might not have our traditional ways of getting a hold of the landlord and the tenant, getting hold of each other. And it's just so important to keep that communication open so that the landlord knows where the tenant is and the tenant knows where the landlord is. Because a lot of these things, Kelly was really kind of emphasizing that kind of working together relationship that can't happen if neither party knows where the other is, and they're going to be more quick. A landlord's going to be more quick to kind of evict, or if they don't know where their tenant is. So I just think it's really important to just keep that in mind, keep that contact open. I really think it's important. And then just what I'm saying, important documents to bring with you. I'm not talking about for entirely for the emergency, but just from a landlord tenant standpoint, this is what you need to remember to bring. Make sure you have a copy of the tenancy agreement, right? Whether you have it digitally so you can access it somewhere else, or you're physically bringing it, you need to have that. Highly recommend any kind of tenant insurance policy, or if you have a manufactured home, you want to have insurance on that as well, because it's just so important. Just having that there, because the landlords are not responsible for the tenant's personal property. Unless the landlord caused the issue, which would be a different situation. But in a natural disaster, that's not going to be the case. if you do have, and I'm going to talk about what you should do if there is a dispute resolution proceeding coming up in a natural disaster, but make sure that if you do have one that's scheduled with the landlord or the tenant, that you're bringing all the evidence that you're going to need for that. Like again, whether that's digitally, meaning you've uploaded it into some kind of system that you can access from a computer, or you're actually physically bringing that evidence. It's just really important to have that because, as we've seen in Lytton and Merritt areas, just getting back, it can be months. We're coming up on a year, almost to a year on some of these natural disasters, and really people have not fully gotten back in. So if there does end up being a dispute between the landlord and tenant, we do know that you must apply for the dispute resolution with the residential tenancy branch. And this is even true if it's a manufactured home. So you do need to be aware of that. I'd also like to point out that even with the pandemic, is just to be aware that even when limitation periods were set aside, that was not true when it came to tribunals. So when it comes to the Residential Tenancy Act or the Manufactured Home Park Act, really what those deadlines are still there. You still have to be aware of them. You're still going to have to meet all of them. There was never an extension on those. So it's just really important to keep that in mind and to keep an eye on that. So you really don't want to lose sight of that. I haven't heard of a case where they've kind of allowed that to slide. I'm sure a lot of you know this. I found that even the pandemic and with the fires and stuff, they really weren't extending anything, and you kind of had to fight it through the normal way you do. And I will get more into that later, but just to be aware of that. So dispute resolution, right? As we know, this is the essential tenant landlord court. And it's under $35,000. So if you're seeking damage on anything, let's say it was the landlord that created the fire or something, you're not going to get that if it's over 35,000. I just wanted to point this out. If you are not covered under the Residential Tenancy Act or the Manufactured Home Park Tenancy Act, you need to be aware that you can then go to small claims. And the reason why I'm pointing that out is if it's a roommate situation or you were sharing that kitchen or that bathroom with the landlord, you can still have remedies. It's just going to be in small claims, right?
Let's jump in real quick. Or the Civil Resolution Tribunal.
Yes, sorry.
Those guys.
I say small claims.
I always forget about those guys too.
I appreciate that. I consider them like similar to the thing. So Civil Resolution Tribunal, it's more likely to be through that because it will be underneath that $5,000 likely. But just be aware that you have other remedies if for some reason it is not covered underneath these acts. If you're filing things with the residential tenancy branch, you're going to pay that $100. As we know, it can be waived. The losing party pays a fee. It's about $156 if you're doing it in the civil resolution and small claims. There's different prices depending on how much money you're seeking. That's about the range. You're going to be looking between $100 and under $200 to kind of do this. As we know, this is done by phone, which can result. Obviously, not. The Civil Resolution Tribunal is all done online. Small claims right now is being done by somewhat by Microsoft Teams and somewhat in person, depending on what it is, but mostly Microsoft Teams. And then, of course, the residential tenancy branch uses phones. The reason why I'm bringing this up is because, of course, in a natural disaster, you now have an issue with that. People might not have access to phones. It can even internet and Microsoft Teams. So this can become a real issue in a natural disaster that you need to be aware of. So if you know a hearing is coming up, it may be that you need to have your client or the tenant needs to move to a location or drive to a location or that has these. Unfortunately, there's really no alternative. And that's really unfortunate. There's no kind of alternative, to kind of get around this. So I just want you to be aware of that. So legal remedies, the reasons in a natural disaster that you're probably going to go to a hearing is if you can't come to an agreement with the landlord or the tenant and the landlord can't come in agreement when we're talking about those other things. What are your rights? If they're not agreeing on those things, then you're going to have to come. If there's disagreement on whether the pad is usable, If it is a case where the park is saying you must make these repairs prior to, and they're giving you 3 weeks when you're in a national disaster and nobody's going to be there to do things are going to be delayed. We know the contractors are going to take, even if you happen to have the money, the tenant happens to have the money, it's unlikely. That's when you're going to want to apply, right? That's going to be a big situation where you're going to want to apply and see that. And like we said, we don't know what the arbitrator is going to say. Some arbitrators are going to be more sympathetic. Some are going to be less sympathetic. And then it's going to be a situation of trying to prove that the natural disaster hasn't completely frustrated the agreement to the extent that there is no way to continue this rental. And I think it's more complicated when it comes to those manufactured home pads, right? This is where that rental, because it could be that a fire's come through and the pad's there and it's all fine. And maybe there's, for some reason, the electricity and the sewer is all there and everything's fine. But then the home, has a smoke damage or, trees have fallen down or part of it's like burnt and the tenant doesn't have the money to fix it. And they didn't have insurance. I know Monte Creek, a lot of people in that area did not have insurance. And in a lot of these areas, it's not even possible for tenants to get insurance because insurance companies realize it's a high risk area because of fires and they're not as close to, they might be outside. I think there's like a gap between Pritchard and Kamloops where there's only like the wildfire covers it. So there's no actual fire department that's covering it. And so it can be really hard to get insurance in there. So it's not even like we're talking about insurance and saying that, but you have to realize that it's not necessarily the tenant's fault that they don't have insurance, right? And there's this idea, well, you should have had insurance. It's not always a possibility. So that's when it might come to kind of head. Another reason why you might do it is the landlord has not returned the rent or the deposit. So if it is frustrated, as Kelly was saying, the landlord needs to apply to keep those deposits. If it's frustrated and it's frustrated halfway through the month, the tenant might be entitled to half a month's rent being returned because they couldn't fully use the rent. They might have paid it on the 1st and then 3 days later, a fire comes through and there's nothing to return to. So that's kind of the things to realize. Now I'm going to say, interesting enough, I'm curious about the manufactured home thing, because if the home burnt down, the manufactured home, and Kelly, you might be able to answer this, I'm not sure how they'd handle this. If the manufactured home burnt down, but the pad was still there, you could technically move a new home on, but I don't know. Maybe they wouldn't return it for part of the month. I'm not sure.
Honestly, like I feel like that's one of those ones where it could go either way, and it would really depend on the landlord. I really think it would depend on the landlord. I mean, they might try to recover as much money as they can and say, well, the pad's still here. But if my argument, I always preface this, my argument would be that there is no more home there to use the services. Therefore, I don't have anything to place on the pad there. There's no more. I would argue frustration in that scenario personally, but
I would too. But like we said, it's not clear.
Never know.
I don't know if any of you have had experience with that and an arbitrator's made the decision, let us know. I haven't heard of one. But like I said, I think these things are really going to come to a head. I think as we see more of these natural disasters, and I honestly think the government will eventually have to address it through legislation. Now, unfortunately, the government legislation is hard to change, so it might take a while before it kind of comes around. So hopefully we'll see these, or it'll go up to a judicial review situation, and the BC Supreme Court will have to make a decision on it. The other reason why you're going to be going there is if the tenant has stopped paying rent. Really, really important. If you have a client that's like, I'm not there, I don't want to pay rent because I'm not even staying there, they have to continue to pay rent. You don't pay rent, you're going to lose. They can issue, and I'll talk about that too, but they can issue, where you have that 10 days to pay it. And that's another reason to keep that communication open. If a tenant is paying by cash and they're getting a receipt, or they're paying by check or something, and all of a sudden you've been evacuated, you can't do that in person anymore. Who knows? Maybe the landlord's gone 3 hours away and the tenant's only gone the opposite direction, an hour away. You really need to keep that communication open and still be paying paying rent. Like I said, it's going to depend on the arbitrator. Let's say, you got evacuated just as you were supposed to pay rent. You're going to get issued that 10-day notice, and you're going to want to get it in anyways. Because I don't think the arbitrators are going to be very, they might not be, and I don't think they will be very sympathetic to not paying rent, even if you're trying to evacuate a family and friends and animals. The other reason, and this can be a very common one in natural disasters, is getting access to your unit. So this would be a situation where the landlord has decided, no, it's the repairs are too bad. I'm not giving you access. And the tenant may want to gain access to get personal items. I heard many stories in Monty Lake and in Merritt, one a fire and one a flood, where people really only got out with the clothes on their back. And a lot of these happen at night, and people are in their pajamas, and they're escaping, and so their personal items are still there. And if the landlord has come in and changed the locks, which the tenant has a right to the keys to if they're still paying rent, which is really important. Landlord may be refusing to give the tenant keys to get back and get their stuff. The landlord may say, no, it's you're out, there's nothing really there. The tenant may have to apply to get in there and to get personal items, or to even get access to the unit, or a disagreement about whether the contract really has been frustrated. Those are different reasons where you're going to have to apply. Another thing I would recommend, unfortunately, when you're talking to people, and I see this question, I'll look at it in a second, but is try to recommend to people to take pictures if they're possible. I've been in situations where I've had to evacuate for fires, and I've actually gone around and taken pictures just so it's clear kind of what was there before the natural disaster came through. Fortunately for me, nothing happened, but it's just really important to take those pictures, or if you know a fire is close by, to recommend clients or yourself to take pictures of the place, so you kind of know what it was originally like versus what it was like afterwards. So it's the question is, I have 2 clients who are being refused access by the band to their homes on reserve to retrieve belongings or repair or occupy their homes. What would be their remedy? I'm trying to think.
That's a tricky one, Andrew, because it depends. Our favorite phrase. Just depends. Sorry, I'll just jump in on this one.
No problem.
It depends on the band. If the band themselves have their own housing policy, I know Kamloops has their own housing policy, and so it follows that process. So each band is a little bit different, but the RTB, the RTB doesn't have jurisdiction to hear disputes on reserve land. So the RTA and the Manufactured Home Park Tenancy Act do not apply when the property is on reserve.
But the Civil Resolution Tribunal in small claims does. So it might be the avenue you would have to go. But first you have to exhaust any process through the actual band.
And it might actually, I think it might go through federal court.
I'd have to look that up. Because I know some small claim stuff does and some of it doesn't.
Yeah, it all depends on what the issue is.
That's true.
So I think when it comes to like actual disputes over possession of the land, I think that might have to go through federal court.
But if it's a tenant, so if you're renting,
no, right? I know.
If you're renting,
but possession
with the landlord. So if the landlord, you'd be going after the landlord.
So it becomes a question of who owns, right? Because Christy Stewart and I've had this conversation a number of times, and I think often it ends up having to go into federal court depending on the dispute.
Yeah. That's what we say. It depends.
It depends.
If you have a clear rental. Okay. So let's say you're actually renting from an individual, you know, they kind of have possession of the home.
Yeah. The certificate of possession. Yeah.
And they're renting a basement suite to somebody. Then you might be able to go after the landlord in that case, who would be the upper part of the home. So yeah, it is going to.
Yeah. So Andrew, I see. So one family rents and the other owns. Yeah. So it's kind of different for both of them.
Yeah, I think it would be different I think one would be federal and one would be provincial.
Yeah. That's tricky.
Do you know, I would highly recommend reaching out to the Indigenous Legal Clinic in Vancouver.
Yeah. Or Prince George. Don't they have one now up in Prince George?
No. So Prince George has the Justice Center there, but their legal clinic is similar to Elizabeth Fry's legal clinic. So they specifically specialize. But the Indigenous Legal Clinic in Vancouver, they would be able to answer that question quite quickly. But I'm pretty sure, I think the one that would rent would be provincial, because I was thinking more from a rental than an ownership. Yeah. I think the ownership would then be federal.
Yeah. Yeah. Andrew, I think like your first step would be to see if the band themselves has their own internal property framework for dealing with disputes like that. And then from there, definitely the legal clinic Odette's talking about. I'll Google that while you continue on, and I'll throw it into the chat.
Nice. Because I also know, there is quite a few that have their own process, because I'm pretty sure West Bank does as well. Yeah. Near Kelowna. They have a quite extensive process. Mm-hmm. So just something to keep in mind. So, this is what we're talking about. If you cannot use all or part of your rental unit, the tenant may also want to apply for compensation for that. So this is example where, maybe, the backyard can't be used, or a portion of the house can't be used. It's been damaged, but another portion can, right? That doesn't necessarily mean that the contract's been completely frustrated. There could be a case where maybe service can't be used. That was previously available, but then a natural disaster has come through. So the tenant is then going to apply for compensation through the RTB for that loss of that kind of being compensated for the loss of the unit or the rental pad, or to get the rent reduced if they can only do part of it. Maybe, the rental pad, water that was provided before is no longer provided, but the tenant can bring in their own water. So that might reduce, the pad, if that was part of the agreement with the park, was that water would be provided. Again, you're going to apply if you disagree that the agreement has been frustrated, right? That's going to be, I could see that happening a lot, where there's going to be, maybe the tenant feels like it's frustrated, but the landlord doesn't. Or I think right now with a rental agreement, more likely the landlord's going to think that it's been frustrated so they can get higher rent, but you never know. Maybe because of the natural disaster, it's going to be harder to rent in that area. So you could see where that situation where you might have to go to the RTP to have that decision made. If repairs to the unit may be done. So maybe the landlord thinks that enough repairs have been done. Maybe they think that, just painting over the smoke damage or the burn damage is enough, but it's actually kind of affected part of the structure of it or something, when it's a simple fix. That's something that you might have to go to dispute resolution as well. And I realize there can be a whole pile of other reasons why you might apply, but sorry about that. But this would be one where you would do it. This would be one where you would do it for kind of more likely to happen with a natural disaster. Like I said before, really important to remember these deadlines. And I know a lot of you know these deadlines, but I just really want to emphasize this because we have not seen situations where these have been extended due to a natural disaster. Hopefully, I think that there should be something at the RTB level or in the acts that do extend it if there's some kind of natural disaster, right? But there isn't anything at this point. So a tenant must apply to have an eviction ended. If you don't pay that rent, right? You get that, the tenant hasn't paid rent. Let's say it came through on the 30th and everyone's fleeing and, everything's chaotic and fire or the flood came through and rent didn't get paid. You're still going to have that 5 days to dispute it and 10-day eviction notice. You have that 10 days to pay for it. You have the 1 month eviction notice. You could see where you'd have the renovation notices and you would have the landlord use. I mean, this is something to take into consideration. A natural disaster comes through. Let's say the tenant's place survived, but the landlord's didn't. The landlord may then be evicting the tenant to move in family members or to move themselves in to that unit because they can no longer be in their own place, right? Or they might say that they're doing that. We've had a few decisions come through where the landlords are saying, yeah, we're moving in, we're moving in mother, and then the mother never moves in. Really important that tenants are really aware of this. And I know you guys are really aware of that, but there's that 12-month compensation, that you get if the landlord didn't do that. Once again, the landlord must apply to keep a damage or pet deposit within 15 days, or they risk having to pay double the amount. That's not going to be extended either, right? It doesn't matter if there's a natural disaster. Maybe an arbitrator might. Some arbitrators I find are a little more lenient on that, and others are not. Others can be really, really strict. And I'm sure you guys, we actually had a case, and it wasn't a natural disaster case, but we had a case where a hearing came up and the arbitrator decided the eviction had been filed, the tenants had disputed it within the right amount of time. Then they had a hearing in January about it. And in January, the arbitrator wouldn't even hear anything, said, nope, you didn't provide the notice of eviction. Therefore, I'm adjourning this, and you have to reapply, but I'm not extending the limitation periods. Then it comes around to March when there's another hearing based on the same eviction. And that arbitrator said, well, because they didn't extend the limitation periods, you technically didn't apply in that 10 days. So so you agreed to the eviction, even though they had originally applied for it. And it was not the tenant's fault that the notice of eviction, it's a landlord's job to prove that, right? So we actually had to judicially review that one. So we had to go to the Supreme Court and get them back into the home because it was the RTB that had created it so that they were filing in January instead of 10 days afterwards because they had filed in 10 days. So that's how strict the arbitrators can be about these deadlines. The courts disagreed with it, so it did go back, but I'm just pointing that out, that you really want to try to make it in because you don't want to end up having to go in that situation where tenants having to go to the BC Supreme Court. It's expensive. You can ask for a fee waiver, but it can be very difficult and complex, right? All other issues besides the eviction notice, you have 2 years from the end of the tenant living in the rental. I'm going to say arbitrators can be, if you've taken a really long time to ask for certain things, they'll be like, well, you've kind of agreed that it's okay. It's kind of like that material term thing. So just be aware of that. It's always better to apply earlier than later. It does say that you have 2 years from the end of the tenancy, but that doesn't mean that the arbitrator is going to grant it. Agree with the tenant, you can apply, but they might say, you know what, you really didn't seem to care about this for such a long period of time. Like, it's just something to be aware of that because I've seen that happen. And then again, the small claims, you must apply within 2 years of the issue arising. So that's a different thing. In small claims, including the Civil Resolution Tribunal, let's say something happened, something happened in March, but the tenancy didn't actually end until September. The natural disaster came through or whatever. The small claims in civil resolution is going to do it from the March, not from the ending of the tenancy, if the issue arose in March. Now, if you're disputing something in regards to regarding the ending of the tenancy, then it would do from that September date. So you kind of have to be a little more careful in that. There's a little bit difference in the way that's worded. So just be really aware of that. So resolving a dispute. So since, I know a lot of you have gone through hearings and stuff, this is more from the end of if there's a natural disaster, right? So what happens if a hearing comes up and you're dealing with a disaster? There's not actually a lot of leeway in the acts to deal with this. But this is kind of what's recommended. I'm not going to say that the RTB is going to necessarily follow this, but so one of the first things you can do if you have a hearing coming up and then a disaster is both the landlord and the tenant have to give written consent to having the hearing moved. So you can see a situation where, let's say the landlord is in Vancouver and the tenant is in Merritt, how the landlord would be like, nope, I'm fine. I'll attend the hearing. And the poor tenant is, has been evacuated and is just trying to keep their head above the water, right? And they don't know where they're going to be living and they're being moved around. I mean, we saw that this summer where so many communities had to be evacuated and people were being evacuated from the place they were evacuated to. So this is the ideal situation where the landlord and the tenant have agreed in writing to move it, but it's not necessarily going to happen. The other thing is you can ask an advocate, a friend, or a family member to attend the hearing to have the date changed. That being said, the arbitrator might turn it down. They might say, nope, I want this to proceed. Likely, I think if that would happen and it really was due to a natural disaster, that the person likely would be you'd be able to judicially review it. But that doesn't mean that you'd be successful at the judicial review. Like I said, that's costly. It takes time. In the situation I was talking about before, the landlord got the writ of possession at the same time we got the stay of possession. And we actually ended up having to go to the courts and getting what we call mandatory injunction, getting the tenants put back into the home, which is difficult to do. So not ideal there either, but it might be the only. Let's say it was the day they got evacuated, right? What are you going to do? You're not going to get written. You're not going to get written position. The arbitrator should adjourn it at that time, but it's not necessarily going to be the case. I've had tenants that have ended up in the hospital, and one arbitrator said, "Yep, I'll agree to have it moved to a different date," and the other arbitrator was like, "Nope, we're proceeding." And then the other thing is, let's say there isn't an advocate, friend, or family. The RTV can put a note on the file saying that you couldn't attend the hearing. And so, again, I think that's similar to an advocate, friend, or family attending. It may or may not. The arbitrator might not even look at the note. I mean, hopefully they would, but it's just to be aware that is another option that is recommended. If you do miss the hearing due to a disaster, so the first thing you're actually going to do is not go for the judicial review. You're going to go what we call a review consideration, which is not actually a hard form to fill out. It's pretty quick. It's pretty easy. They get back to you fairly fast. I found they can get back to you within a few days to 15 days. So they're pretty quick. And I'm saying that in COVID times when the RTB has been a little slower about things, so which everywhere has been. But that would be the first step that you would take, and then it would be kind of that judicial review. Then, if you don't, the other one is if you don't have the evidence needed. So let's say you were evacuated, and it was that time where you were evacuated, and you just got out with the clothes on your back, and maybe there's some pets and everything, the tenancy agreement, the notice of eviction, everything was still at the home, and you've lost that. You're going to attend your hearing and then ask for that adjournment again. Like I said, you never know. You're going to try your best to your abilities. You're going to, if you fail at that, you might have to do that review consideration and then that judicial review. Realize it's a very, very quick turnaround from when the decision comes down to when you have to apply for that reconsideration by the RTB. Kelly, I don't know if I want to say, I can't, off the top of my head, I can't remember how many days it is, but it's really quick.
It's 2 days.
Yeah. And it was super quick.
2 days from the date of service.
Pardon?
2 days from the date of service of the decision.
Yeah. And so that's something to note, that it might not even be possible. So you might have actually missed that window, and then it would have to go to the court because judicial review is 60 days. Correct me if I'm wrong, Kelly, but I'm pretty sure it's 60 days. I'm really bad with remembering numbers because for the longest time I thought it was
30, and I was freaking out over a file. We need to get this out. Nope, it's 60 days. It's 60 days. Right. Both Mark and I had that panic.
I've had that panic. I'm always like, is it 30, 60, or 90? Because all the different acts have different timelines. So sometimes you always have to look it up. So that's what you're going to kind of want to look at. the other situation that we were talking about, so what happens if with service, right? So you might actually have to apply to the RTB for alternate service if you can't serve, by person, mail, leaving in a noticeable place or mailbox at the person's address. This is an interesting one. And I'm just going to point this out. We've looked at the case law around this, and I've had clients who've said, no, I didn't get the notice. I didn't get the notice. The courts are not sympathetic to that. I think it would be in a natural disaster, you'd have a reason. I mean, I think it would be hard for the landlord to say, I placed it on the door when there was evacuation. I think in that case, you might be successful around that. But even by registered mail, they will say, no, we're going to deem it served, even though you're saying you didn't get the notice. So it's really hard to fight that one by fax or by email. Now I'm putting a caveat on the email thing. The email only works if that's been provided you can't do that for the initial dispute. It's if the other side has allowed you to do it by email. And even then, sometimes the RTB can be a little picky about that. So I usually have them confirm that they're willing to accept it by email, and then I email it, and I will provide that in evidence to the hearing. It's helpful, usually when I've done that, it's been a lawyer on the other side as well, or another advocate on the other side, and we've just mutually agreed to that. Or it's been a landlord on the other side, and they might be a management company. So I'm not worried about them saying no to it or anything. But you will have to show that you actually had permission to attend it by email, or they won't accept it. And so this is including, evidence, alternate service for evidence, and alternate service for the initial dispute, notice of a dispute. And I think we talked about this before, but the landlord is supposed to provide you with an updated address. So if the landlord is evacuated, it is a requirement that they provide you with an address that you can actually get in contact with them. So it's not good enough for them to try to argue around that. I don't know how that would play out in a hearing. I haven't had a situation where that's happened. So it'd be interesting to see what the arbitrator said. But technically, the landlord is supposed to provide an updated address, and that's how I would argue around it. If you didn't get the other side's documents, which very well could happen, right? Registered mail sent, you've been evacuated, you didn't get it, the mail gets held. I know people that were kind of in the Monty Lake, Falkland area, where their mail was going all kinds of different places. They're expected to pick it up in, Kamloops one day, Kelowna another day. Then you're going to want to do some of these other things, right? If it was a notice of the hearing and you missed the hearing, that's when you're going to apply for that review consideration, right? And then if that's not successful, then have to go to judicial review. If you did not receive the notice to end tenancy, you're going to apply for dispute resolution. They can be really picky about those dates, but you're going to apply for the dispute resolution, and then you're going to try to argue that you didn't receive it. Like I said, the courts are not sympathetic to you just saying. You're going to have a pretty compelling reason why you didn't. The tenant's going to have a compelling reason why they didn't receive it. The case law has deemed service many times, even if the person hasn't picked up the package from the mail. So it's just something to keep out there to be kind of conscious of, that you might have to argue around that. This is the communication part that I think is really important. I think it's ideally both sides are keeping in contact with each other, and they should be getting the evidence to the other side and being clear how to do so. So reaching out to the other side and saying, hey, how would you like me to get you this evidence? I highly recommend that if they do say drop it off at this place, make sure that there's a witness that sees it happen. And there's some kind of written confirmation that was an appropriate way to do it. Right? So if you're doing it in person, then it's fine. Have the witness. That's where witness says it in person. The reason why I say witness is it's always better to have someone else say, yes, I delivered this to the person. I knew it was that person, than you saying it yourself, because you might not, the tenant saying it themselves, because they might not believe it. But you really should be clear to the other side just be really, really clear about how that evidence should be delivered. And that I like to always have things, like I said, by email. If we've agreed to serve it by email, that it's in writing that it was agreed to, not just over the phone. So why dispute? We've kind of talked about this. The landlords might dispute so they can get the rent, an order of possession if the tenant's just disappeared, or an order of possession if there's a disagreement about the frustration. Access to the unit, the landlord might need access to the unit and the tenant's refusing it. The tenants might need access to the unit because the landlord's doing it. Reducing the rent, we've talked about that. If services haven't been provided, there might be reducing of rent. So we've talked about how, like, if you've been, if a natural disaster comes through, how you might, you still have to pay rent, but you can't pay the full rent. The tenant should be paying the full rent until they apply for dispute to have that rent reduced. So they would continue to pay the full rent, apply to have it reduced. And, because they weren't there, maybe they got evacuated for 10 days, right? They got evacuated, there's a fire nearby, but now they're allowed back in. Repairs, if they're not doing the repairs, or to end the tenancy, especially if there was a fixed term kind of tenancy there where they had to, they agreed to rent it for 12 months and this is month 9, they might have to apply to end that tenancy so they're not having to cover for that 10, 11, 12 months. Something that if people need to be really aware of, the landlords do not have to pay for secondary accommodation. So if there's a natural disaster and there's an evacuation, that the landlord doesn't have to pay for the hotel room in that other location. That is the tenant's responsibility. Of course, usually the government has some kind of system in to help out with that, but it's just really important to note that the landlord does not have to pay for that secondary accommodation. Now, that is different if the landlord was at fault. So if it was something like a burst pipe that had nothing to do with a natural disaster, the landlord then may have to pay for accommodation, but that's not the same if a fire or a flood came through, or, a windstorm. We had a lot of tornadoes where I grew up, that kind of situation. The landlord doesn't have to pay for that secondary accommodation. And then we just kind of wanted to talk about something to just be aware of. This is actually, so the rent bank right now for most of BC is through Elizabeth Fry Legal Clinic, kind of oversees that. There are some other organizations, and Kelly was smart enough to remind me about this. Mention it, because what is the rent bank? So in a natural disaster, the rent bank might come in real handy, right? People might not be able to work because they're having to evacuate, reset up somewhere else. They might, be losing some money, but it's a temporary situation, right? Like, let's say it's a 10-day, and then rent's coming up and they can't pay for it. What is the rent bank? The rent bank is more than just a lender. It's not just lending money. They help with housing stability and homeless prevention resources. So it's a government program that's trying to prevent this from people becoming homeless due to not being paid for rent for some unexplained, temporary reason. For clients experiencing financial shock and housing insecurities, you can see where natural disaster would fit right into this, right? And they really do try to use a range of approaches to address clients' issues. So it's not just like, oh, here's the money, kind of go away. So they provide financial assistance to tenants who cannot pay rent. So they may give money for that rent, or utilities. So this is something that's important to remember. They actually cover for essential utilities too. And sometimes that can be where tenants have a lot of issues, is they have enough money for the rent, but then the hydro bill was higher. I mean, we had that huge heating crisis, right? I would say that's a natural disaster as well, right? We were having record heat. And, you could see where air conditioning or something might up a lot of these bills more than normal. Or if it's particularly cold winter, it could be the opposite way, right? So these essential utilities is something that, a tenant that is kind of living more day to day or month to month might have a lot of issues with, and this will kind of cover that temporary so that they're not getting evacuated. They help tenants who are unable to pay damage deposit of the first month's rent as well, and offer other critical supports that can lead to more stabilized and substantial housing. So things like that is they might advocate on behalf of the individual with the landlords. They might be able to come up some agreements between the landlord. They will help advocate with utility corporations. A lot of advocates, I know a lot of the advocates do that as well. They'll help, BC Hydro, they might help come a deal and mediate conversations there as well. And they also know about a lot of the referrals too in the area for access to food and clothing. So you can call into the organizations to make appointments for this, but the best way, if the tenant is able to, is to apply online. And this is kind of that online. That's the website you're going to want to go to, bcrentbank.ca. So it's a pretty simple, website address there that you can apply to.
Yeah, and I think the one that in particular that with respect to helping out with the damage deposit, I think that one's of particular importance when we talk about people who have to move as a result of a disaster. I mean, the landlord is required to pay it back, right? But they have 15 days, and you don't have 15 days to wait to get that damage deposit back to apply to a new home. And so that's really a really key component, I think, in light of natural disasters. One other agency is the John Howard Society here in Kamloops. I know that they have like emergency rent grants, but I think that there are some conditions on that with respect to whether the person is seeking rental assistance when it's a subsidized housing placement, because that's already, heavily subsidized. So I think John Howard might have that limit, but I'm not 100% on exactly how that works. But I do know that they have emergency grants to try and help prevent homelessness for some clients there. So, yeah. And
these loans are like interest free, right? So they do get paid back, but it's not, you're not dealing with a lender who's charging interest.
What? You're not in the process of charging interest? Jeez. Oh, Lord. So just a really quick brief on the legal clinic. We help out the geographical service area for our services is Kamloops and some of the immediate communities around. So Merritt, Ashcroft, Cache Creek. I think for a little bit we were going out to Lillooet, but that's a little bit outside our range at the moment. But we offer free legal services for clients that financially qualify for our services. So it is a poverty law clinic, and the services are primarily operated by the students. And so myself and Ted Murray, and then we now have finally got ourselves another part-time lawyer, Neela Howes. So we oversee their work. So we do all sorts of residential tenancy work. One thing I'll just point out, I don't know what it is with respect to tenancies. We've been getting a lot of people wanting to end tenancies early. So if you have clients coming to you who are like, I just can't handle living there anymore, and it's a fixed term lease, there are very specific rules that they have to follow. And even then they might be on the hook for the cost of renting the place out to a new person. So make sure you tell your clients right out the gate, don't just leave. Because then you're going to be on the hook for a lot potentially, right? So I just wanted to, just as an aside, because we've been getting a lot, like I'd say in the last month, we've had like 4 or 5 files of that nature, and it drives me nuts. It's fixed term, fixed.
We've had a lot of landlords trying to evict.
Yes,
a landlord use or rent eviction. So I'm glad that's kind of changed. That's what we're seeing.
Yeah, so that's the legal clinic. We do a lot of other stuff, some family. We don't do contested family issues. That's Odette's neck of the woods. And we happily will give some advice and then send them over to Odette. Small claims, civil resolution tribunal, human rights, employment standards. But usually like the first point would be to say, just call, set up an appointment, and then we'll go from there. Because if we can't do full representation on the file, at the very least, we can give some summary advice. We also do wills, powers of attorneys, and representation agreements for clients who qualify, which I don't think there's really any other clinics that do it around the interior. Yeah. So that's us in a nutshell. Odette, what are you guys all about?
So we do a lot of similar things to the TRU Community Legal Clinic. One of the things I'm going to say is I have really, really appreciated, because our clinic obviously started in 2019, kind of at the end of 2019, where TRU had been there for years. And we have a really good working relationship. So I just want to make that clear. Really, we do referrals back and forth. In our clinic, we can represent in the Supreme Court, British Columbia Supreme Court as well, and have done so. So we'll do judicial reviews right to the BC Supreme Court. We see a lot of employment issues and a lot of human rights right now, especially around employment issues. Yeah. And then obviously small claims and civil resolution tribunal, we've actually been successful. Technically, you're not supposed to have representation, but we've been successful. So if you are an advocate and you want to know kind of how to what to kind of put in there to get them to allow you to represent your client, we've been fairly successful. We had one turned down, and then we submitted an affidavit. The client could not handle technology at all, and they didn't accept that. But then we gave them an affidavit from the assistant saying, yeah, like this is what I had to do to even explain to them how to file to have a representative. So just to be aware that it is possible. And I know TRU does the same thing. And I know that TRU does have students. We have article students. We don't have students from the university, but I did work there for quite a while, and the students are very supervised, and I would say provide good representation. We also, I'm just trying to think, we cover we do family law. So we have a clinic in Kamloops as well as Kelowna. So we do cover a wider area. So in Kelowna, we'll go down to Penticton, go up to kind of that Enderby, Coldwater, Vernon area. I might be kind of wrong.
Coldstream.
It's Coldstream. I'm like, it's not Coldwater, it's Coldstream. And then we come up to Salmon Arm there, and then over to kind of Clearwater, Blue River, over to Lillooet, kind of down to that Ashcroft, Cache Creek area, and around to Merritt. So we do have like a wide, extensive area, and we kind of divide Kelowna, Kamloops, kind of the Kamloops clinic. If you call, we'll refer you to which one to be with. But obviously, if you think about it, if you're closer to one, then that's probably where it's going to go. And what we have is we have a property law advocate, like a lot of the advocates here. And then we also have a family law advocate, which I'm sure a lot of you are familiar with, which does do that kind of helping with those, filling out those documents of family law. But where I think Kelly was talking about is although I don't do trials or anything like that, what I do is, what I can do is if there's a contested application, just a short application, there's no legal aid lawyer on the file yet, I have jumped in and done things like substitutional service applications or overturning a separation agreement.
No big deal.
Yeah. The occasional kind of protection orders. Protection orders. Sometimes you need that protection order right away. You can't get that legal aid lawyer right away, and we're able to jump in and get those protection orders. I've also done a 48 apprehension underneath the Mental Health Act as well to get someone assessed. So that is the other thing we can we can also cover. So that's kind of our area that we kind of that we cover, and we're. The other resource I have on here is, and I'm sure a lot of you know about it, but you have to mention it if you're talking about residential tenancy stuff, is TRAC, right? The Tenancy Resource and Advisory Center. I look at their stuff. I mean, they're one of the first places I go when I want to question about something and I'm looking at something, because they're so great at just having resources on there and just providing resources when it comes to these issues. The other, I'm honored to be able to, present here with Legal Aid BC, but I want to point out that their website has some really good resources. They have great step-by-steps when you're doing family law. I've gone on there and used it myself just to double check something or to see something. I mean, I was working with a retired judge, and we were trying to figure out something, and we were actually using it as a resource to say, yeah, we're right, the registry's wrong, kind of thing. So, it is a really good resource to kind of use. I just wanted to put that out there, that these are all great resources that you can look at yourself or refer clients to. And honestly, us lawyers use it too. So It's nothing. I think they're great resources to keep on top of things. And when things change, they have things out there, classes in other places. They often have stuff up there as well on their website. And there's many other, clinics in BC. The Law Foundation has a list of them as well. And I know there's some questions, but I'm just going to put this here.
We've got one about strata fees. What's the allowable annual increase for strata fees? I'm going to straight up, I don't know strata too much. I don't know strata law. So this might be have to answer after.
I don't know if there is a restriction on it. Strata is a very particular area of law. It's I used to do it way back in the day, but I feel really uncomfortable answering this question. The Civil Resolution Tribunal deals with almost all strata issues.
Yeah.
So I do know if there's a dispute about it, that's where you're going to go. I think they have to have a reason for increasing it if it's too much, but I'm not sure on that. So I'm reluctant to say that because I just don't know the answer. It's very act-based and regulation-based. And so that's where I would recommend is going to look at the act.
Yeah. What I can do is, so we have Neela, who our new part-time lawyer. She knows stratas very well. So I'll ask Neela and send that answer out to Baljinder to send to the group.
And we'll still take some questions and stuff. I just am putting this up here. So if you want to phone in and leave your email, you can call that phone number that's there for Kelly and leave your email, and then they can answer it, or put your email in the chat, and perhaps Kelly can write it down, and then they'll send you the answer to that question.
Yeah. And
you can send your email just to the panelists. You don't have to have it so that everyone can see it.
Hello, hi, Kelly and Odette. Do you think there is a session valuable to do on stratas as well? As you mentioned that you have a lawyer in your office, and it will be easy for us to do it because there are many questions that people ask around stratas and other concerns in this kind of housing industry.
Yeah, I can definitely talk to Neela. She's just getting her feet under her with us at the moment. So it might be one of those ones once you resume, say in May, June kind of thing.
Maybe May, June. Yeah, nothing urgent right now, but in future we can talk about it.
Yeah, absolutely.
I always say that strata law is worse than family law when it comes to the ability of people to fight. I did do it.
Very true. Very true. Yeah, that's it. Yeah, and it's such a niche area.
It is, and it changes, and it's very statute based and regulation based, and it has been underneath the Civil Resolution Tribunal for a while.
Well, and I find too, it also depends on the strata itself and what their rules are, and
yeah, contract based.
Yeah. Is there anybody else with questions, or? And we whipped through quite a bit of information.
Oh, you guys have done amazing. It was such a wonderful wealth of knowledge that you shared with everybody. Like always, if you have any questions, please feel free to ask both of them as they are here right now for a couple more minutes.
We're just that good.
You are. No question.
See, my head, every time I do one of these sessions with you, Baljinder, I always leave feeling so good about myself.
Well, you are. I always speak about you. It's you are such a wonderful wealth of knowledge, and I rely quite a bit on you guys. So thank you so much.
Well, I don't know about Odette, but I feel like every time I get to do one of these sessions for Legal Aid BC, I feel like I end up learning or refreshing my knowledge more. So it's honestly, it's just as much a benefit for me as it is, I'm hoping at least for your attendees.
I think Odette presents quite a bit for Provincial Advocates Conference as well. And, we kind of rely on Odette as well. And we kind of bother her quite a bit actually with our questions and answers.
Well, I'm sure like everybody, I look forward to when we can do it in person, and then Odette and I can rip it up.
Kelly, I need to come to Kamloops. I think we should do a conference in that area. I'm really waiting. I'm doing my first one in Surrey, actually, on March 22nd. Nice. You both are welcome.
Oh, man. In person.
I'm going to say when Kelly does her presentation for you guys on of attorney and representation agreements, even though I know a bit about it, but I think I want to attend, and I'm sure I'll learn lots.
It's
especially if Carrie joins us.
You know, in Carrie's presentation, I learned about lawyer vaults, which I never knew about. It's always, every piece of learning is, you know, it's valuable.
What was it that you learned?
It's lawyer vault, where you can keep your documents. Yeah. You know, I never knew about that.
Yeah.
So that was a very good piece of information. You know, besides we have lockers or other things, I think this is the safest place, you know, if in case of natural disasters or if you lose your documents, you know, you can always find it there and as a notarized copy. Mm-hmm. So, you know, it's, I think that's wonderful.
Yeah.
I think there are no more questions. And thank you, Callie, and thank you, Odette.